Judgment. My name is Harrison Kinyajui. With your very kind indulgence, I do appear for a petitioner in petition E586 of 2024. And my Lord, my Lady, we filed an application in the Court of Appeal to arrest the delivery of this judgment. This was after the 4th of June. The same petition was not heard when you had directed and ordered it be heard on this, on the 7th of June, 7th of May. You had ordered, directed it be heard on the 4th. On that 4th, it was not even listed for a mention. It was listed for a hearing. Because your initial direction was that that petition should be heard as a standalone petition. Then, together with that, would now be the judgment of the court, because the Honorable Chief Justice had appointed your lordships and my lady as the bench in that petition and as a bench in this petition. Now, when on the 4th of June, the said hearing aborted, we filed an urgent application before the Court of Appeal. CO application number 291, E291 of 2026. I also wrote an email letter to the Chief Justice as the head of the judiciary to bring into her attention the precipitate injury and ruinous violation of the petitioner's right to be heard before you render yourselves in this petition. Accordingly, the Court of Appeal certified that application is urgent. This morning, I served on everyone, including all the parties that are before you now. That application relates to the Court of Appeal's jurisdiction under Article 165(3). And therefore, in deference to the authority of the Court of Appeal, the matter being sub judice in the Court of Appeal, to arrest the delivery of a judgment, so that then a judgment can be rendered that is encompassing that petition and the consolidated petitions. I had, in deference to Section 20, subsection 1H of the High Court Administration and Organization Act, informed the Deputy Registrar the equivalent of the least pendants rule, that application being alive before the Court of Appeal, that this Honorable Court then defers the delivery of the judgment. My lords, as I close, my lady, the right to be heard, being enshrined in Article 25C of the Constitution, it is non-abrogable. It cannot be abridged. But if this judgment is rendered, and peradventure, you find, as indeed you would find, that in petition E586 of 2024, that there was no impeachment, the constitutional threshold was never met, and then you grant that petition, you nullify the impeachment, you render the decision according to the pleas of the petitioner in the amended petition, then your lordships, and my lady, if peradventure you were to dismiss the petitions, hearing, it would be very embarrassing. So I suggest, in deference to that constitutional authority of the Court of Appeal, that you defer the rendering of this judgment. We can be heard tomorrow, because we filed some submissions ready for the 4th of June in that E586. And then the ship can sail. You can render a judgment, whether to dismiss or grant. Thank you.
Do you have an order from the Court of Appeal on this issue?
The Court of Appeal, as a matter of judicial notice, my Lord friends will be aware, has the way of disposing of any matter.
I don't think we are ready for argument. I've asked, do you have an order from the Court of Appeal stopping or arresting this judgment?
As we speak right now, no, because the order of business,
you have
the Court of
answered
Appeal.
me. You have answered me.
May I finish, Judge?
You have answered me, and I have accepted that answer. I will now ask some of the parties here to respond to that.
May I finish before they respond? Just for good order. My lords and my lady, we do not in the least, I do not in the least want to bring any theatrics or sabotage the administration of justice before you. What has provoked this particular move to the Court of Appeal is the aborting of the hearing on the 4th of June 2026. And so that Malala friends can respond. On the 7th of May, before you, Learned Senior Counsel Professor Agitho Mugai gave me the podium so that then you could address everybody in E586. On that day, you gave, in the presence of everybody here, the 4th of June as a hearing date. So that as they address that, it is common ground that that petition was to be heard before the date to render the judgment was given. Thank you, Your Lordships. And thank you for giving me this opportunity.
The subject matter raised by Mr. Kinyajui relates to a file which is not before us here. And we have not taken any record in this particular file. But for the purposes of transparency, I will ask the parties who are expecting a judgment from us for their comment.
My lords, my ladies, I have the instructions from the team of the first petitioner, His Excellency Rigathi Gachagua, to make representations on his behalf. We have come here to pick the judgment in the petition before you. We have not received any order from the Court of Appeal stopping today's proceedings. We actually, as a matter of fact, not participating in that matter at the Court of Appeal, and therefore it will be very curious for us to have our legitimate expectations to get a judgment today interfere with a matter in which we are not participating. In the absence of a formal directive from a court higher than this, the Court of Appeal stopping this judgment, we ask you to deliver our judgment as scheduled today. That's all.
Thank you.
Of the 44th petitioners, my lord, I associate myself with the submissions made by senior counsel. The fact that that file is not before you, my lord, cannot form the basis upon which this judgment can be deferred. And most importantly, my lord, counsel having not given sufficient reasons, my lord, for adjournment, my lord, or arresting the judgment, my lord, I think the legitimate expectations of the 4th to the 49th petitioners, my lord, is that you render yourself as you set your mind and yourselves to do this afternoon, my lord. We are opposed to that application.
Thank you.
In the interest of time, I will speak for all my colleagues, for the respondents, and we associate ourselves with the submission of learned senior counsel, Mr. Ongoya. Yes.
Thank you.
My lord, on behalf of the third interested party, we associate ourselves with the submissions of the lawyers for the petitioner, first petitioner, and wish that, my lord, you could deliver judgment as it had been agreed before. I thank you, my lord.
Thank you.
Your Honor, on behalf of the second petitioner, we associate ourselves with the submissions of the other petitioners, and we say in the absence of a court order for stay, then we see no need of stopping judgment. That's all. My lords and my ladyship, appearing for the 43rd petitioner, we also associate ourselves with the submissions of Senior Counsel Longoya, and in the absence of a clear order and in respect of our legitimate expectations to deliver the judgment, we then oppose the application. Thank you.
Thank you.
If it may please you, my lords and my lady, I remember actually as the 58th petitioner, I remember when my petition came for consolidation, we were together with my senior, Mr. Kinyajui, and he opted not to have his petition consolidated in this petition. So he has his day in court. The court can give directions in his petition. And there are also other petitioners who are not also consolidated in this matter. So for this, I will fully associate with the submissions that have been given by Mr. Ongoya that we proceed. This court is full, and everyone is waiting for this judgment. Much obliged.
Thank you.
My lords and my lady, if it pleases you, speaking on behalf of the 9th petitioner, I will wish to fully associate myself with the submissions made by my senior and my teacher, Senior Counsel Zebedee Ongoya. My lord, over and above that, perhaps it will benefit the court to notice that we have only but been served with the application. So in any event, even in the absence of the order, even if we are to agree, we have not been given enough or sufficient time to understand in full flavor the application that has been made by my senior, Mr. Kinyajui, and for that matter, we'll be urging the court to proceed with the business of the day, to render the decision. Mr. Kinyajui, my senior, can pursue his claim at the Court of Appeal. Thank you.
Thank you.
I think the point is made, my lord. I will add the following. One, it is presumptuous for Mr. Kinyajui to address you as though it is a given that the Court of Appeal will ultimately grant his request, and therefore, as already submitted, there is no basis for that request he makes as we speak. Number two, if you were to grant his request, nothing would stop all the other petitioners in the cohort of petitions that were equally held in abeyance pending the delivery of this judgment. So there is nothing special about his petition that would require a different approach. Number three, my lord, the record will show that throughout these proceedings, Mr. Kinyajui has tried through one contrivance or another, through a letter of lamentation or another, to scuttle the process. This is just one of the series. It should be dealt the way the others have been dealt with. Thank you.
Mr. Kinyajui, I'll give you a right of reply.
Thank you very much. There is no need for Learned Counsel to cast aspersions on me. At no time did I seek to stop these proceedings. Secondly, a voice has been raised there. On the 29th of May last year, a year ago, your lordships and my lady made a ruling saying, and I quote, "This petition raises very weighty constitutional issues that are distinct from the consolidated petitions." By reason of which I'm answering that issue, that this is an impromptu, an afterthought, knee-jerk reaction. That's not so. That particular ruling of the 29th of May 2025 deconsolidated these E586 of 2024 from the consolidated petitions. That is the decision of the court, not my decision. Shouldn't the petitioner have abided by that decision? Yes, he did, and yes, he has. The 7th of May, everybody here was present when that decision was made to hear that petition. I'm answering, my lord, I'm answering because they say that this is something that I've just come up with to scuttle the hearing. It's my rejoinder, with tremendous respect, my lord. And I'm not going to take too long. I'm alive to the fact that this court is on a constitutional duty. My Lord, the date for hearing was fixed in the presence of my learned friends. I served that application from the Court of Appeal in deference to the Court of Appeal's directions. And we cannot sit here and pretend, as legal practitioners, we do not know the practice of the Court of Appeal. The Court of Appeal is seized of these proceedings. And this court is subordinate to the Court of Appeal. And I'm answering that issue as to no reason has been preferred to defer this judgment. The Court of Appeal being seized of those proceedings, which everybody here is fully aware. My friend has said, yes, he has been served. Everybody has been served. So we ought to give deference to that constitutional issue. The other issue raised is that, Your Lordship, there's nothing peculiar. There is nothing out of the ordinary from these consolidated petitions. Learned Counsel, really, having looked at my petition, never having answered in that petition, Muthomi Thiankolu never filed a single sheet of paper in that petition. And he's appearing for the 10th respondent. Your Lordship, he cannot be heard to say that he has absolutely no reason to see what is peculiar. Your Lordships and my lady, you saw the peculiarity of that petition. You saw, and I'm not going to go into those grounds, Your Lordship, I'm not going to go. So that, Your Lordship, the petitioner wants to be heard on merit because Article 25C says he should be heard and given that right to a fair trial. As I close, none of my learned friends here, when that petition comes up for hearing, should they ever remove from their pocket the res judicata card. None of you. My Lord, I say so because they are happy to have the judgment today. And I'm going to demonstrate there was no lawful impeachment. Constitutional threshold was never met, and I'm not delving into that. So none of them, my Lord, none of them, no, Prof, please don't point a finger at me. None of them should be heard to say that my client's petition is res judicata. So that Your Lordship,
Mr. Kinyajui, yes, we have given you enough time.
Yes, this is my last remark. This is my last remark. Since the Honorable the DR received this formal communication and was brought to the attention of this honorable court, I very believe this honorable court should have deferred to the Court of Appeal. And I said, we're not adjourning indefinitely. It's not open-ended. Even give me this afternoon, we'll be heard, and then you can render your judgment tomorrow. Thank you for hearing me.
Mr. Kinyajui, this is the brief ruling on this matter. First of all, we want to note for record that the matter you are referring to is not before this court, either by way of a mention or a hearing or a judgment. Indeed, it is not before us, and we are not able to take notes on that matter. Secondly, because many people here may not know where you are coming from, you yourself sought to be deconsolidated in that matter. And we gave you the orders the way you wanted them. You took yourself away from these petitions. We have made a decision on that. You will not misrepresent facts. Listen, I'm making a ruling on this matter. The matter is not before us. The Court of Appeal has had or has cited that matter. If they wanted to stop us, we would drop our pens. give us a court order from the Court of Appeal, then we'll drop our pen. We don't have anything like that. Lastly, we gave directions the last time we were having this matter. We said that your matter will be mentioned after today's